We will get started with introductions and just an overview of this series. My name is Denia Pérez. My pronouns are she, her, and ella. I'm the legal services manager here at Immigrants Rising, and I'm really excited to welcome you all to the first of our UndocuThrive with or without DACA webinar series. We have wanted to create something for the community in light of all of the anxiety and limbo that we're probably all feeling given the state that DACA is in. And we really just wanted to acknowledge that so many people never qualified for DACA and that we have been working as an organization to support everyone regardless of where they are in their journey. So throughout this series, we'll be sharing information and resources that will help you better understand the legal, educational, mental health, and entrepreneurial opportunities at your disposal. There's a lot out of our control, and that feels really overwhelming and scary, but there's also a lot of ways we can assert agency over our lives and take back our power and make decisions for ourselves as, we also continue to hold this uncertainty. So thank you all so much for joining us, and thank you to my fellow legal services colleague, Jesus, who will be helping us today with tech. He'll be sharing our slides, and also big shout out to Grace from our comms team for helping us monitor the chat and helping us with tech issues. We will have time at the end for Q&A, but we just want to put a disclaimer before we begin to let you all know that we will not be answering any specific questions about people's individual case or eligibility for DACA or any other immigration option we'll be presenting on. This webinar series and this particular webinar that we're doing today is really just to give you all an overview of where things are with the various lawsuits with DACA, where it will be going moving forward, and how you can prepare and learn about other options that might be available to you through some of our resources. So no legal advice will be given today, but if you have any questions specifically about the information we will present, we will gladly answer those. So with that, I will turn it over to Krsna to introduce himself.
Hello, everyone. Thank you, Denia, and thank you, Immigrants Rising, for having me today. And I see that there's people from all over the country. It's good to see that we're reaching a wide net. My name is Krsna Avila, and I'm a staff attorney at an organization called Immigrants, Immigrant Legal Resource Center. I was going to say Immigrants Rising, but I do have a connection to Immigrants Rising. Before I went to law school and became an attorney, I was undocumented myself, and I was part of Immigrants Rising. So I was also working at that organization in the legal services program. So it's good to be back. So like Denia mentioned, basically today we're going to go over what's happening with DACA. I know a lot of you have questions about the current changes. So we'll be diving into the litigation, what the rule means. And then Denia will talk about, the importance of assessing permanent benefits, so that even though we know DACA is temporary, and it's important for you to assess whether you're eligible for a green card through various ways. So that's what we'll be discussing today. And then at the end, we'll have some time to do Q&A. So as Denia mentioned, we can't answer specific questions about your case, but we can give general information. So feel free to use the chat or the Q&A portion of the Zoom to ask any questions throughout the presentation. So with that, we'll go ahead and get started. Jesus, if you can please share the screen. So we'll first be talking about the DACA rule and what that is, since I know many of you have questions about that. Next slide, please. In order for us to understand what the DACA rule is, we first want to kind of get a summary of the litigation around DACA, since it's a little bit confusing. But basically, a common question that we still see is like, wait a minute, didn't DACA go to the Supreme Court back in 2020? Didn't the US Supreme Court already decide what's going to happen with DACA? Why are we still litigating? Why are we still talking about lawsuits? Well, it's important to know that that litigation was actually very different from the current litigation that we have right now. So the litigation in 2020, the case that went up to the Supreme Court, was all about basically how Trump had tried to terminate the DACA program. If you all remember, in 2017, I believe, when Trump first came into office, he tried to terminate the program, and a bunch of us as advocates basically sued the Trump administration, and we try to argue that the way he terminated the program was unlawful. So that's what that case was all about. Basically, the Supreme Court agreed that Trump had terminated DACA unlawfully. Unfortunately, basically the state of Texas, I believe last year or 2 years ago, brought a new lawsuit where the state of Texas tried to argue that the program itself, DACA, was unlawful. So this is again completely different. Now we're basically on the defense, trying to argue that the program itself is lawful. And one of the main arguments that Texas is making is that when DACA was first introduced back in 2012 by President Obama, that when he first announced it, he actually didn't go through the proper procedure in implementing DACA. So basically they said, hey, if the federal government wants to implement a program of this magnitude, you actually have to go through what's called notice and comment. So that means that before you even implement a program, you have to first announce it to the public and give the public a chance to comment on the program. So to give feedback, give suggestions, things like that. And Obama didn't do that. So that's what Texas is arguing, or one of the main arguments, I should say. And so that's what's going on there. Next slide, please. So basically what ended up happening in 2021, last year, July, was that a judge in the US District Court of Texas basically agreed with the state of Texas and found that the DACA policy was unlawful. So what it did was that it vacated that original memo that had created DACA back in 2012. So it basically said, hey, this memo that Obama used to create DACA is unlawful. But because we still want to litigate it, we're going to allow folks that have DACA to continue renewing as we continue arguing whether the DACA program is lawful or not. So it remanded the program back to the Department of Homeland Security. So it gave the Biden administration a chance to fix the issues that the judge highlighted in the program. Next slide, please. So as many of you know, in October, so October 5th, basically the Fifth Circuit, which is the court above that district court, agreed with the lower court and said that the DACA program was unlawful. But again, it was talking, all of those arguments were about the DACA program under the Napolitano memo, which is the memo that Obama used to create the program. But because it realized that the Biden administration created this new DACA rule, the Fifth Circuit basically said, hey, we have this new DACA rule. That's not what we're arguing throughout the case. Because there's this new rule, I'm actually going to give it back to the lower court for that judge to decide whether this new rule is lawful or not, because we didn't argue that, because obviously the rule wasn't in place yet when they were arguing throughout the courts. So what ended up happening was that on October 14th, that lower court basically said, okay, fine, we're going to litigate and try to assess whether this new rule is lawful or not. But in the meantime, we're going to place what's called an injunction, so that we're not going to allow new applications to be adjudicated. So we're still going to allow renewals to happen, but new DACA applications will not be processed. You're still banned from doing that while we continue to litigate and see if this new rule is lawful or not. So that's what's happening right now. Next slide, please. So what is this DACA rule and what does it do? So basically it did go into effect on October 31st. So it basically, this rule seeks to remedy, again, that notice and comment requirement that Texas said that we didn't go through back when it was first announced in 2012. So as many of you know, this DACA rule, before it was finalized, did give the public a chance to give suggestions. So it actually went through that procedure. What it does is that it actually replaced already that original memo. So now when the government is analyzing the DACA cases, it has to go to the DACA rule and it has to follow those instructions, which I'll talk about in a little bit. It's not that different from the memo back in 2012, but there are some differences. But basically it replaced that memo. What it does is basically codifies DACA into what are called regulations. So, and I know that's like a legal term, but basically now we have actual kind of law and policies that we can cite to when we're trying to make arguments about DACA. So it basically protects DACA a little bit more. Now it's no longer a memo. Now we have actual policies and regulations in place. One thing that we were not so happy about is that when they gave the chance for us to give comments, we were trying to advocate for them to expand the DACA requirements so that other folks can also qualify beyond the original, you know, coming before you're 16 years old and all those requirements. But unfortunately, the government didn't listen to us, and the new rule keeps the same DACA requirements as in the original 2012 DACA program. Next slide, please. So some differences from the proposed rule to the final rule. So as I mentioned, it gave back last year, it published the proposed rule where like now the public was able to give comments. So we do see some differences between that proposed rule and the final rule. One of the things, for example, that they tried to do was to separate out the employment authorization from deferred action. As many of you know, right now, and since 2012, you basically didn't have the option and you could apply, you have to apply for the employment authorization and deferred action. Well, the proposed rule tried to separate those out so that folks, if they didn't want to work, for example, they can just apply for deferred action. They didn't have to pay for the employment card. But under the final rule, it's basically, it reverted back to the original kind of way of doing things, which is now you have to apply for both when you're applying for DACA. One of the things that the proposed rule tried to do too, which we didn't like, was that right now, as many of you know, DACA requirements do have some criminal offenses that would bar you from renewing DACA or maybe one day applying for the first time. But certain states like the state of California allow you to expunge certain convictions, which basically means that it allows you to go back to the criminal court and erase that conviction from your record. Or say, you know, right now, if you have a felony, for example, that's a bar to DACA. Well, in California, you can go back in certain cases and lower that felony to a misdemeanor to allow you to qualify for DACA. So under the final rule, it still recognizes that. So thank God that they continue to do this. So that means that if you have a conviction and you're in a state that has expungement avenues, you can probably do that and still qualify for DACA. Another thing, which is actually new, is that now before they terminate your DACA, they have to give you a notice of intent to terminate. So that's basically a form that you would receive, um, summarizing why the government is trying to take away your DACA. So for example, I know of a case of a person who left the country. They had DACA, they left the country without applying for advance parole, which you shouldn't do. You should always apply for advance parole. Under the old rule, your DACA is automatically terminated. So they don't give you a notice. As soon as you leave without advance parole, DACA is done. Under this rule, they first have to give you a notice of intent to terminate. So they first have give you the opportunity to argue that you're still eligible for DACA. So it's kind of another procedure that's in place, that's good for you to try to argue that you're still eligible. So for that person, they can try to argue, hey, I left the country, but it was on an emergency basis. Please don't take away my DACA. I have significant ties in the United States, et cetera, et cetera. So it gives you the chance to argue to still keep your DACA. And then lastly, it keeps the protection. So it protects the information in your DACA applications and associated applications. So advanced parole requests, for example, it protects that from being used for deportation purposes, generally speaking. So of course, there's exceptions if they think you're a threat to national security. We're talking about terrorism and things like that. So in that situation, they might be able to use that information but for everyone else, it keeps those protections so that they're not able to use that information to go after you. Next slide, please. So what's next? So I mentioned that right now the district court is basically deciding whether this new rule is lawful or not. But at the same time, I mentioned that in the meantime, it did allow the rule to go into effect. And while they continue litigating, once the court actually decides whether it's lawful or not, either party can then appeal once again back to the Fifth Circuit. So, or they can appeal directly to the Supreme Court. So if the judge decide that the rule is not lawful, then we can appeal to the Fifth Circuit, or we can appeal straight to the US Supreme Court, or we can appeal to the Supreme Court after the Fifth Circuit. So basically, what does that mean? The litigation is not over, unfortunately. I mean, it would be a surprise if the judge sides with us and says that the rule is lawful. That's what we hope that would happen. But if not, then the litigation, unfortunately, will probably continue. Next slide, please. So where does that leave us? Basically, current DACA recipients can continue renewing and should continue renewing. Previously issued DACAs continue to be valid until their expiration date. And then something important is that folks that are eligible for advanced parole, you should try to go abroad if you can, if you haven't already done that. Unless there's like a big issue in your case, if you were arrested before by an immigration officer, or if you've been in contact with the criminal legal system, then in those cases, you should definitely talk to an attorney or a legal representative to assess your case. But everyone else, there's so many people who have gone abroad and have come back, and you want to have that in your record in the future in case DACA ends, because a legal entry can help you down the line. So for one of the most common examples is if you marry a US citizen spouse, that legal entry would allow you to complete your green card process inside of the country. So if you haven't already done that, travel abroad. Many people have done it. Immigrants Rising has a resource that has also a lot of stories of people who have gone abroad on advance parole. Next slide, please. All right, so now we'll talk about basically DACA renewals. So As I mentioned, so right now, the only applications that are being processed are DACA renewals. So you're able to renew if you, of course, have DACA right now and it hasn't expired. Also, you're able to renew if your DACA expired, but the expiration has been for just less than a year. And so that's important because we don't want you all to have an expired DACA and wait for a year or more, because unfortunately, once a year passes, right now at least, the government is treating those applications as initial DACA applications. So they would not be processing those applications. So it's important for you to renew on time. And if you have it expired, to at least not allow yourself to have a 1 year expiration date on your DACA. Next slide. So when should you renew? So if your DACA expires 6 months from now, definitely renew as soon as possible. That's kind of the time frame that the government suggests. If it's more than 6 months, you should continue renewing. But speak to a service provider. Obviously, I think the biggest risk is that they would deny it and they would keep your money. So that's definitely one risk of just you losing your money. But depending on your state, there's like, for example, here in the state of California, and it's true in other states too, there's actually a lot of money for nonprofit legal service providers to pay for your DACA. So if you don't care about losing money, especially if there's funds in your state, it could be worth renewing, even if your DACA doesn't expire more than 6 months from now. But yeah, you should definitely talk to a service provider or an attorney to see what your case is about. Next slide, please. So in your renewal request, that's the same forms that you're filling out, the same kind of things, except that, so it's obviously the I-821D, which is the DACA form, the I-765, which is the application to get your employment authorization card, the I-765WS, which is the worksheet that you also need to include to explain why you need to work. And then along with the $495. And then what's optional is the G1145 if you want to get notifications on the process of your renewal, and a G28 if you're basically represented by an attorney or an accredited rep. I should say that right now they just updated the forms. So make sure you're basically starting January 3rd, they're going to only accept the new forms. The I-821D, the I-765, those are updated. So make sure that you're downloading and using the most recent form if you're submitting your renewal after January 3rd of this coming year. Next slide, please. Also wanted to let y'all know that you can submit these renewal requests online. So it's actually easier. You can also pay online, the $495. So right now you can submit the I-821D and the I-765. You can submit the I-765WS electronically, but what you can do is download it, fill it out, and then upload it. So there's a chance for you to upload extra documents as you would like to include other evidence of like continuous residence, for example. So you would do that with the I-765WS. You would upload that document. And then just wanted to let you know that DACA renewals are being approved relatively quickly. Right now we're seeing about 2 to 3 months, possibly sooner. But yeah, make sure to get those in on time regardless. Next slide, please. And so this is kind of the same question as like, what if my DACA expired more than a year ago? Or what if I've never received DACA and I'm applying for DACA for the first time? Is it worth applying? So I think once again, I think right now at least they're not adjudicating the initial DACA requests, so they're just holding on to them. So there could be some benefits. The benefit is obviously if they ever do reopen the DACA program, you'll probably be first in line to receive an approval. A risk, obviously, is that you will lose your money if that doesn't happen. But again, many states have funding for DACA applications, so it might not be a problem. And also, there is a risk that if DACA ends, that your information is out there. So that's just something to consider as you try to assess if you're submitting a DACA application right now. Next slide, please. So yeah, that's just what I just said about DACA renewals. Advocacy, next slide, please. Just wanted to let folks know real quick before I pass it to Denia that there are some advocacy, there's some advocacy going on for folks that don't have DACA. That's important to keep an eye out. So right now there's basically a law that passed in 1986. If many of you might remember or have heard about IRCA, which basically was the law that gave amnesty, quote unquote, to folks. Basically, back in the 80s, a lot of folks were able to get their green cards. But what a lot of people don't know is that that same law, for the first time, made it a crime to employ someone who's not authorized to work. So an employer could get criminally in trouble if they hire undocumented workers. But there's some advocacy going on around this. Next slide, please. So right here in the state of California, a group of UCLA law professors are basically pushing the University of California to hire undocumented workers. And they're basically arguing that that law in 1986 doesn't apply to states. So they're basically saying that that law, they acknowledge the law does prohibit employers like corporations, companies, the federal government from hiring undocumented workers, but it doesn't apply to states. So that would be huge if it doesn't apply to states, because that would mean that states and local governments can now hire undocumented workers. So we'll see where that goes. Right now, they're just basically advocating for this to happen. They're starting with the UC system here in California. But if they win and they're allowed to open the doors and hire undocumented workers, that could be a huge deal for other states as well. And I believe that, and I just wanted to quickly mention that there is federal advocacy. Right now, there's the Dream and Promise Act that's in Congress, which would allow for a pathway to citizenship for folks that are eligible for DACA, but not just DACA recipients, other immigrant youth as well, and also TPS holders. So that's kind of their registry update, which is basically, there was a law back in the day that allowed certain people that came in by a certain date to get a green card. So they're trying to update that so that the date is now more current. So that's another form of advocacy. Also, advocacy efforts in case DACA does end is for the Biden administration to at least create another program called Deferred Enforced Departure that's similar to DACA or Deferred Action, but it's different. So there's a lot of advocacy going on. But to be quite honest, I think right now, especially now that we lost the House, or it seems like we're losing the House, and then what's going to happen in the Senate, that could be up in the air. But there are some groups that are advocating for this to happen. So with that, I think that's it for my portion, right? Or yeah. So I will now pass it back to Denia.
Thank you, Krsna, and thank you all for your questions and for being so engaging. Krsna is going to answer what he can as I'm presenting my portion. So Jesus, feel free whenever you're ready to queue up my section. There was a lot of information shared about the litigation, whether or not to apply for advanced parole, the DACA rule. So please continue to ask those questions either in the Q&A or in the chat, and we will answer them in real time for those who maybe have joined us late. We are recording this webinar because we want to make sure we memorialize this information. We will be sharing it on our website. So if you're frantically taking notes or not able to stay or know people who weren't able to make it, we got you. And thank you again for joining us. And thank you, Krsna, for that overview of the litigation and the rule. So I want to talk about different options, different long-term options that we screen for here at Immigrants Rising. I'm going to be talking about our screening tool, the ILLIS, and also just different pathways to a green card that you may or may not have heard of. So this is an overview of what I'm giving. So next slide, please. We'll get started with some of the most common options that we see for young people, undocumented people. So as you all know, DACA, TPS is temporary. These do not, unfortunately, provide a pathway to citizenship, and our immigration system is very, very complicated. So I don't expect you all to be experts at the end of this or to have a full understanding of what each of these options can do, just giving you all a tiny preview so that in case some of these sound like they might be beneficial to you, you fill out our ILLIS and we are able to screen you and provide you with a lot more information. So in general, there are different pathways to become a green card holder. There are family-based petitions, so that, like the name implies, a family member will sponsor you, will petition for their undocumented family member. And then there's employment-based petitions as well, where like instead of a family member who's petitioning for you, you have an employer who would be doing the sponsoring. And both of these options within these two categories have pathways to citizenship. Next slide, please, Jesus. We also have humanitarian-based options. So as the name implies, a lot of these options, unfortunately, are based in a traumatic event or something really painful that has happened in someone's life. So, for example, asylum, many of you may or may not have heard, is for folks who are fleeing their country, fleeing persecution, based on either their race, religion, or membership in a particular, what's called a particular social group. And so there are a lot of different requirements for that, but in general, you know, it's for people who are coming from countries where they're facing persecution or will face persecution. It comes with a lot of different benefits, including, you know, a social security number. You're able to sponsor family members to come on if you're granted asylum. But there is a 1-year deadline to apply. So the tricky thing with asylum is like you have to ask for it within the first year you're in the US. There are certain exceptions for that 1-year rule, but in general, you have to show that you were previously persecuted or will face future persecution on account of one of these, what's called protected grounds. So basically like who you are fundamentally as a person, your religion, the group that you are a part of is being persecuted and you wouldn't be safe back in your country. We also, just very briefly talking about each of these. So SIJ, or Special Immigrant Juvenile Status, is for folks who were abandoned, abused, or neglected by one or both parents. And this particular option, we find actually a lot of people might not know or think they're eligible for it because they think like, oh, like abuse, that's a really big word, or like neglect. But like a lot of folks have actually been eligible for it because it's either one or both parents. It doesn't have to be both, but it's just if one parent, you know, if you haven't been in touch with one parent for a really long time, like they don't provide for you, they don't send you money, you haven't talked on the phone, and you're under the age of 21, you're not married, you know, this could be potentially something you're eligible for. Neglect is also very broad. It's based on different state law, but again, you know, people whose parents, you know, made them go to work instead of going to school, or didn't provide adequate like housing or food, like all of that could potentially be a grounds for asserting neglect and applying for special immigrant juvenile status. It's a two-step process where a family court has to make what's called a special finding order, a determination that one or both parents either abandoned, abused, or neglected the child. And depending on the state that you're in, child can range up to age 18 or age 21. And so this is something that's available to people who are able to get screened for this before they're 21. And again, who faced either that abandonment, abuse, or neglect, and it wouldn't be in their best interest to go back to their home country. So again, hard stuff, right? Like persecution, abandonment, abuse, neglect, these are all very heavy things. But fortunately, there are these options where you can take those experiences and maybe apply for something more long-term in the US. The next option I really quickly want to talk about is called VAWA. So it stands for the Violence Against Women Act. And even though it has women in the name, it actually exists to protect people of all genders. And it's really meant to provide a way for people who have been in abusive relationships with a US citizen, spouse, parent, or child, or lawful permanent resident, to be able to basically self-petition. So earlier, I very briefly talked about family petitions and how certain family members can submit a petition for their undocumented relative so that they can get a green card. And sometimes, those marriages or that parent-child dynamic can be abusive. And so this law, the immigration aspect of it, exists so that if someone has been abused, not just physically, it could be emotional, it could be financial, and their US citizen, spouse, or parent, or child has not moved forward with the application for a green card, that person basically is able to self-petition for themselves. And again, even though the word women is in it, it's for people of all genders. And the important thing, though, is that the undocumented person who's being subject to that abuse has to have like a formal relationship. So, either married to a US citizen who is abusive, or if they're a child, like their parent has to be, like their biological or adopted parent has to be a US citizen or LPR, lawful permanent resident, or vice versa. If, the parent is undocumented and their son or daughter is being abusive, it has to be either their biological child or a child that, is theirs by adoption. Similar to VAWA, but different, is the U visa. So the U visa was created essentially to try to create more trust between the immigrant community and law enforcement. A lot of folks in our community who are undocumented don't report crimes because they're afraid. There are a lot of things to be afraid of with law enforcement, right? And so in an attempt to try to ease some of that fear, the U visa was created basically to incentivize folks to report crimes that they have experienced or that they've witnessed. And so it exists to protect victims or survivors of crime. And essentially, if you are someone who has been subject to there's like a list of crimes that could qualify someone for a U visa. If you have been a direct victim, or you've been a witness to a crime and have cooperated with law enforcement in reporting that crime, and also have suffered substantially emotionally or physically as a result, you might be eligible for a U visa. And again, it's for people who are direct victims or who have witnessed something and have cooperated. The big piece is that you definitely have to report it or be active in the investigation of it, because again, the whole point of creating this was to try to incentivize undocumented folks to come forward and work with law enforcement when there was a crime. There are a lot of other requirements, but like I mentioned, just giving you brief snippets, because really what we want you all to do is, if any of these sound like they could be an option for you, we really want you to fill out our intake service so that we can screen you, because we won't be able to get into all the details of each one of these tonight. We just want to give you an overview and let you know, like, all of these things are things we screen for, and all of these things do lead to a green card. So we want to make sure you're aware that they exist, so that maybe if you can't benefit, like your family member or a friend like keywords we're sharing, so that you are aware of their existence and that hopefully you can seek out more information. The T visa is for victims or survivors of trafficking. And it's not just, sex trafficking. It could also be people who were brought over for labor or being exploited or being underpaid or not paid at all. There's a lot of different ways that legal representatives can get creative in arguing like that someone was trafficked here. So again, big things to remember is like, okay, were you brought over, under false pretenses? Like, was your passport taken away? Are you not being paid? Was there ever a time where you were being exploited for your labor? So these are, again, key things to think about, because this visa exists solely to, again, help people who have been victims of any kind of trafficking and were brought over to the US as a result of, being exploited in this way. Lastly, so diversity is kind of its own thing. It's not necessarily humanitarian. It was really created actually to boost Irish immigration, because there was a time where we weren't getting enough Irish immigrants to the US. So it was really to benefit them, but now it benefits more than just folks from Ireland. It's really meant to, again, incentivize immigration from countries that don't send a lot of people over. So if, definitely not Mexico or China or India, unfortunately, because we have a lot of our folks from there coming over. But for countries that send, like less than a certain amount of immigrants a year, there's this lottery called the diversity lottery that you could apply for. And it's what it sounds like. It's a lottery. It's all based on chance, but you can apply. And if you get it, you get a green card. So again, if you are from a country, that doesn't send a lot of immigrants to the US, like this might be an option for you. Next slide, please. We all know what DACA is, so I won't go into detail about that, but we also screen for that. We all, if people have questions about their renewals or their pending initial application, I know we got a few questions on that. We answer those questions as well. TPS, again, is for folks who are from a country that has been designated by the Biden or whoever's the president at the time, as a country that would benefit from TPS because either there's civil unrest or there's been usually like a hurricane or other natural disaster that would not make it safe for that person to return. So unfortunately, for example, a lot of the countries most recently that had TPS designations like Sudan, Venezuela, a few others are countries where there's a lot of unrest there. And so for people who are already in the US and are undocumented from those countries, they get to apply, but unfortunately it does not help people who are outside of the US. And this is another thing, it's not more long-term, but we answer questions about it, we screen for it, and just generally give people information about this. So family-based petition, again, just for the sake of time, we're gonna kind of fly by because I wanna make sure we have time for y'all's questions and the ILLIS, but like the name implies, for family-based petitions, there are certain folks who can submit an application for their undocumented relative. US citizens can submit them for their spouses. Children who are US citizens, or not children, sorry. So parents who have children who are undocumented. So the parent is a US citizen, their child is under 21, they can sponsor their children and their parents. So if you are a US citizen son or daughter over the age of 21, you have an undocumented parent and you are a US citizen, you can sponsor your undocumented parents. And then for lawful permanent residents, we have folks also able to sponsor their relatives. Parents who are green card holders or lawful permanent residents can submit applications for their unmarried sons or daughters. So a son or daughter is basically anyone who's 21. Once you're 21, you're no longer a child under the eyes of immigration. And so for lawful permanent residents, they can sponsor their over 21-year-olds as long as they're not married. And they're also able to sponsor their children. Children are people who are unmarried and under the age of 21, and they can also sponsor their undocumented spouses. So we'll go to the next slide. Again, employment-based employers, similar to family-based, there's different categories. So different employers who work with people of different skills or abilities, we have these categories. And so employers are able to potentially sponsor an employee. We have in the first category, people who have extraordinary ability, and they have like first priority. There's this thing called the visa bulletin that basically changes every month, and you sort of get to see, like, depending on when your application was filed and what category you're in, how long you have to wait for your green card. And so with family-based petitions, the categories are based on the relationship between the family member, the country of origin, and like when the petition was filed. For employment-based petitions, this little chart is, instead of like the family relationship, it's like these categories. They have these different categories with advanced degrees, extraordinary ability, having a baccalaureate, and like when the petition was filed. So we're gonna just skip through this because I talked a little bit about each of these. And again, really what we want y'all to know is, like, we screen for all of these, and we will go into more depth when you fill out our ILIS, which I will talk about now. So the Immigration Legal Intake Service, or the ILIS, is Immigrants Rising screening tool. And fun fact, Krsna was one of the brains behind this operation. It was once upon a time called the Dreamer Intake Service, and it has turned into the Immigration Legal Intake Service. But essentially what it is, it's a free, anonymous, confidential screening tool that anyone with access to the internet can use to basically have an overview of potential immigration options for them. We know that in our communities, depending on where you live, depending on your comfort level talking to an attorney, or even if there's any attorneys available or near to you, you may or may not have ever gotten screened. So we created this service so that people could get a sense of things they might be eligible for without having to go in person, without having to pay money, and without having to maybe share some really hard information. Like I said, a lot of these immigration options are based on people's trauma and like hard things that they've gone through, and that can be hard to talk about with an attorney. So this service is completely anonymous. We actually encourage folks to use aliases. So if you've ever wanted to be Beyonce or, Cardi B or whatever, we encourage you to just like create an alias so that we don't need to know your real name, but the answers should be accurate, right? Like we do need to know like your actual, like when you came to the US, what country you're from, whether you've had interaction with the criminal legal system, like all of that needs to be correct, but the actual name that you use can be something else because that helps with the confidentiality part. So next slide, please. What happens when you fill it out is that, again, we provide you with informational memorandum about your different options. And again, it's available to anyone who is undocumented in the United States who has questions about what their options are. So if you're undocumented, you live in the US, and you're curious about what you might potentially be eligible for, you are a great candidate for the ILIS. However, like if you have a student visa, like if you have some other legal status, this isn't really the service for that. It's also not for people who are in active deportation proceedings. And it's not because we don't want to help you or answer your questions, but with someone who is going to immigration court who has active deportation proceedings, that requires a quicker response. And so our service is really meant for people who don't have active proceedings, who have questions, and who need to get screened and just understand their options. Because it does take us, 4 to 6 weeks, a little bit longer, depending on how much of a queue we have to get back to you. So we want to make sure people who are not in emergency deportation situations to use it, because it takes us a while to process them, because we train fellows who are interested in immigration law Our fellows do the draft, and then Mari, who's another attorney on staff, does the review. And then after she provides feedback, make sure all the information is correct, then we send out this memorandum. So that's why there's, this wait time. So that is what our ILLIS is. I talked about what it is, who it's for. It takes about 15 to 30 minutes to complete. So, again, depending on whether or not you know the answers to questions like, when did you first arrive to the US? Did you have any interaction with CBP? Have you ever been in deportation proceedings? Like, depending on whether you know all of that already off the top of your head, it could be really quickly. But if it's information you have to dig up or ask your parents or other relatives about, it could take a little longer. But overall, in general, we say 15 to 30 minutes to actually complete. And you'd hear back in 4 to 6 weeks. Once you get it, depending on what we identified for you, you might be getting a follow-up call. We also have another amazing person on our staff, Francisco, who conducts follow-up calls to make sure that people understand the information that we provide. If you are eligible for something, we really want to make sure we get you in touch with a legal service provider in your area to move forward with that. And so that is an option. If we don't identify any long-term remedies, we do still provide other resources for you, educational resources. And if you have any questions once you receive it, we have a legal intake at immigrantsrising.org email where you can send us any questions that you might have about the information that we provided for you.